find out the Exhibit A from this
Yes, my lord, yes.
court records. Exhibit A, yes, I've got it.
That is a temporary permit.
It is from 8/8/2013
नहीं
to
8 मार्च है लॉर्डशिप, वो 3 जो है ना वो घुमा हुआ है, 8 मार्च है, नीचे में देखिएगा 7 मार्च को इशूड है।
8 मार्च 2013 से 4/7/2013.
Yes, and the date of accident is
2 मार्च।
2nd May.
so there was no permit. There was no permit.
But your lordship may kindly see para 11. What is the justification by the learned court below? If your lordship may kindly permit me not to place para 11 of the impugned judgment.
Yes.
That dealt with Lord issue number 2 and 3 liability part. Your lordship may kindly see, Lord, fourth sentence, that this policy including the requirement of the said driving license. In this case, the learned counsel for the opposite party insurance company has submitted that there is violation of the terms and conditions of the insurance policy, and in this connection, permit has been issued by which it has been marked as Exhibit A. However, I find that in this case, there is no specific denial of the insurance policy of the truck, and so I find that at the time of accident, vehicle was insured with the opposite party insurance company. Thereafter, may skip 2 lines. Thereafter, the next page. From perusal of Exhibit A, it transpires that the permit has been issued in the name of Ranjit Kumar Rai in connection with vehicle number such and was for rural area. That is mentioned in the temporary permit itself. Rural area of Jharkhand, and it was valid from 8th March होगा हुजूर, वो हो गया 8/8/13 to 4th July 2013. That is the correct date.
This is correct.
From perusal of the Fardban, such and such, it transpires that the accident took place in village such and such within the district of Saraikela. So I find that even as per the Fardban, accident has not taken place in the town area. An accident took place on 2/8/2013, and I find that at the time of accident there was valid permit for flying.
How you justify this finding that there was a valid permit?
Admittedly, my lord, the date of accident is 2nd August.
The tribunal has confined only the place of accident.
Yes.
Valid, a permit should is valid once the date is there or the period of validity on and the place or the area which is covered within the permit.
Area. So far, under court below is concerned, but area is perfect. Area there is no error.
Confined to the area, I also agree with him. The area is okay, but
that is the only reason assigned. That is the only reason assigned by the learned court below, but that is apparently wrong.
Yes, not considered.
No, apparently wrong, my lord. He did not consider the date of accident as well as the validity of the permit. My learned friend is correct in this regard.
Now you are the owner.
I am the owner, my lord. So therefore, right to recovery may be, yes, that can be. And I also, my lord, that is out of the court, my lord. I can also concede to that effect that
I will not record your concession.
Yes,
right to refute.
Yes, that is my submission.
I'll dispose it of.
Yes.
And two additional pleas are there. I know I don't sustain it, my lord, but still. It contributed deceased ka tha, so but no evidence was led by us. And second is my lord vis-a-vis interest, that is at rate of 8%.
Now, one thing may I be permitted to point out: the policy was valid. Policy was covering.
That is why
in violation of permit. There was no permit.
Yes. This appeal is at the instance of the insurance company, first off, the insurance company has challenged the award dated 29th February 2016 in compensation case number 116 of 2013, passed by the District Judge 3, Motor Vehicles Accidents Claim Tribunal, Jamshedpur. First up, the learned counsel, Mr. Ashutosh Anand, appearing on behalf of the insurance company, submits that admittedly there is a violation of the terms and conditions of the policy. Thus, the right to recover, thus the principle of pay and recover should have been applied by the tribunal in this case. As per him, the accident has taken place on
2 March
2nd of 2013, and on that date, the offending vehicle, which is a truck, did not have a valid permit. First up. In absence of permits, the truck couldn't have been allowed to ply on the road, and thus could not have been allowed to ply on the road. Full stop. It is his contention that since the vehicle plied on the road without a valid permit, there is a violation of the terms and conditions of the policy. Thus, the insurance company is not liable to indemnify the owner of the vehicle, and rather the right to recovery vehicle. Full stop. He contends that in the aforesaid fact, the tribunal should have granted the right to recover the amount which the insurance company was directed to pay. We recover the amount from the owner of the vehicle, which the insurance company had paid by way of compensation to the claimants. Good stuff. He also takes another ground of the ground of contributory negligence. First up, as per him, there was the deceased was also negligent in driving the vehicle. Thus, as per him, the tribunal should have held that there was a contributory negligence on the part of the deceased, and should have apportioned the amount of compensation. These are the 2 points only.
And interest 8%.
As per him, the interest at the rate of 8%, which was imposed, is on the much higher side. Next paragraph. Mr. Sahani, appearing on behalf of the owner of the vehicle.
My submission is that the insurance policy was valid. That is 30th March.
Admittedly, the insurance, the vehicle, the offending vehicle was insured with the appellant, and the policy was valid on the date of accidents.
Yes.
Since the policy was valid at the date of on the date of accident, the liability is upon the insurer to indemnify the owner. He also submits that the tribunal has discussed the issue of permits and has answered and has arrived at a finding that the accident took place
on 2/8/2013. Died on 6/8/2013.
Place at village Nandidi, Nandidih, Nandidi, which is within the district of Saraikela. And since the vehicle was permitted to ply within the rural areas of Jharkhand, and since the said village falls within the rural area of Jharkhand, the vehicle was being plied with a valid permit. He submits that in view of the aforesaid finding, it cannot be said that the vehicle was being driven without a valid permit. Next paragraph. From the nature of argument advanced, And considering the scope of this appeal, which is very narrow, this case is being disposed of at this stage itself, as the lower court record has already been placed before me. Full stop. The issue raised by the insurance company is very limited. Full stop. The quantum of compensation and the assessment, the assessment of the assessment of compensation is not under challenge. Full stop. The only challenge is in respect of the validity of the permit and the issue of contributory negligence and the rate of interest. In view of the limited issue which are being raised, this court is only answering the aforesaid issue without is only deciding the aforesaid issues which has been raised in this. Next para. The first issue which has been raised in respect of the validity of the permit. First up, the said permit was exhibited as Exhibit A. First up, after going through the permit, I find that the same permit was issued on 7/3/2013. Full stop. In column 9, from column 9, I find that the vehicle was permitted to ply as a goods carrying vehicle in the rural areas of Jharkhand. First up. Admittedly, in this case, the accident has taken place in village Nandidih, Nandidih, which is a rural area within the state of Jharkhand. So far as the area is concerned, one cannot say that there was a violation of the condition of permits, as the vehicle was duly permitted to ply in the said area. This doesn't close the issue. Full stop. The vital point is the period of permit. Full stop. From column 10 of Exhibit A, I find that the permit was valid from 8/3/2013 to 4/7/2013. Full stop. The permit is a temporary permit issued by the Secretary, South Chotanagpur Regional Transport Authority, Ranchi. Full stop.
But this plea was not taken in the written statement. That has been taken note by the learned court below, with regard to specific plea with regard to permit.
This is a point of law. Full stop. From the aforesaid document, it is quite clear that the permit was issued after the accident had taken place, as the accident has taken place on
2/8/13.
2/8/2013.
2 March.
2 March.
2/3/2013.
Yes, he's right.
Who has produced this Exhibit A?
That is by the insurance company, most probably. Of course.
Who has produced this Exhibit A? What's up? there is nothing on record to suggest. Tell here 2000 full stop. Thus, it is clear that on the date of accident, this permit was not in existence. Full stop. There is nothing on record to suggest that on the date of accident there was any other permit. Full stop. Since the parties are relying upon Exhibit A, and the court has also relied upon Exhibit A, comma, I hold that this Exhibit A, which is the temporary permit, was issued after the date of accident, and thus it can be held that the vehicle was being driven without a valid permit on the date of accident. Let's stop. Next paragraph. The another issue which has been raised by the insurance company is the question of the is in respect of contributory negligence. First time. It is the case, the counsel for the appellant, insurance company submitted that there is a contributory negligence, there was contributory negligence on the part of the deceased, which was not taken note of by the tribunal. First time. While I go through the judgment, I find that judgment, I find that no issue in respect of contributory negligence was framed by the tribunal. Further, the fact, the question of contributory negligence is a question of fact which needs proof. The insurance company admittedly has not adduced any evidence in this case. First up, in absence of an evidence, comma, it cannot be held that there was contributory negligence which can be attributed to the deceased. It is well settled principle of law that the fact of contributory negligence needs to be pleaded and proved, and the person or the party who pleads and takes this plea needs to prove the same. Full stop. The Honorable Supreme Court in the case of so and so has held that in absence of any pleading and proof in respect of contributory negligence, the tribunal cannot arrive at a finding on the aforesaid issue. Full stop. Thus, I find that the tribunal has not committed any error, in absence of evidence. Very good. Very good. Thus, I find no illegality in this aspect. Thus, I find that no illegality has been committed by the tribunal. The Honorable Supreme Court in the case of so and so, take down, has held so and so. It is necessary to the Honorable Supreme Court in so and so in paragraph 10 has held as follows. Quote paragraph of Meera Devi's judgment. So far as Next paragraph. So far as the rate of interest is concerned, I find that the tribunal has exercised the jurisdiction vested upon the tribunal and has awarded interest at the rate of 8% per annum. First up, I find that no illegality has been committed by the tribunal. First up, next paragraph. Considering on what has been held above, and since I have held that there was a violation of the condition of policy, comma, the right to recover, the principle of pay and recover should have been applied in this case by the tribunal. First up. Thus, I modify this award only to the extent that the amount of compensation should be paid by the insurance company, and the insurance company will be at liberty to recover the said amount from the owner of the vehicle. First up. This appeal is this partly allowed.
Statutory amount, my lord.
Oblige.
So the statutory amount deposited by the insurance company at the time of filing this appeal should be refunded to the insurance company by the registry.
Interest part may be directed for disbursement, my lord. Interest part.
I will give no direction. It's already there.
Much obliged.
The direction is already there.
Yes.
Yes, next.
Number 33 and number 245 or 70, Mr. Vijay Shankar Jha, Mr. Pradeep Kumar for appellant, Mr. Dr. Mr. Vijay Kumar Sinha for respondent.
May please Lordship, may be heard the my lord, the impugned order my lord, serial page 25 my lord, in
25.
which my lord, the applicant has been dismissed my petition my lord.
The petition was dismissed.
My lord, stating that my lord, since the accidental fall has not been proved by the applicant my lord. My lord, may be heard the my documents my lord. Firstly, my lord, exhibit 4 my lord, page 20 my lord,
Exhibit
which has been
4.
filed by exhibit 4 my lord at 20 page 20 my lord in my application my lord.
Exhibit 4 is the next.
My lord,
Just a minute, let me see.
प्रथम सूचना प्राप्त हुआ देखा इसे पंजीकृत करें अंतिम प्रतिवेदन पर अभिलेख प्रस्तुत करें. नेक्स्ट माय लॉर्ड 25/7/13 भागलपुर रेल थाना यूडी के संख्या 37 सूचना के अंतिम प्रतिवेदन प्राप्त हुआ जिसमें मोहम्मद शमशाद का मृत्यु अज्ञात ट्रेन से होना बताया गया है. देखा तदनुसार अंतिम प्रपत्र स्वीकार किया जाता है. This is the my lord in respondents exhibit my lord. My lord, second my lord, the my lord page 21 my lord, the inquest report my lord, exhibit A5 my lord.
Yes.
किसी अज्ञात ट्रेन से कटकर मृत्यु होना my lord. Before my lord, last before 3 para my lord.
Yes,
किसी
yes.
अज्ञात ट्रेन से
What is the evidence?
my lord, evidence my lord, is supported my lord, the who filed FIR my lord, they stated my lord, my lord, appellant AW2 मोहम्मद जुब्रेल उम्र 33 बरस स्वयं यह कि मैं इस दावाबाद की आवेदिका मेरी मां है एवं मृतक मेरा सहोदर भाई था. यह कि मेरे फर्द-बयान के आधार पर रेलवे पुलिस ने यूडी कांड संख्या 37/13 दिनांक 9/6/13 निबंधित किया जिसमें मैंने मृतक मोहम्मद शमशाद जो ट्रेन से कटकर छत बिछत अवस्था में था की बात पुलिस को बताई थी. यह कि पुलिस के पूर्ण जांच के बाद यह स्पष्ट रूप से सामने आई कि मृतक किसी अज्ञात ट्रेन से गिरकर कटकर हुई है। यह कि इस शपथ पत्र में उपरोक्त सभी बातें सही है। My lord, thereafter, my lord, they have filed DRM report, my lord, and they have also exhibited, my lord, by on 8/9/16, my lord. My lord, R2, my lord, it express, my lord, IPF Kahalgaon submitted a report which concluded that above fact and circumstances, it is clear that this is fallen down on his own and resultant
Where
the
is
sustained injury.
which one? Which is this document?
My lord, DRM report, my lord,
Exhibit
exhibit R2, my lord.
R2.
My lord, page 11, my lord. Page 1, my lord.
No,
Sorry.
no, no. Let me see. Let me see from the exhibits.
R2,
R2.
my lord.
This is a DRF report.
In heading, my lord, not seat, my lord. Next, my lord, R3, my lord, also, my lord.
Yes.
Para 10, my lord, brief fact of the case. As per report of IPF Kahalgaon on 9/13, village so and so person informed to Bibi Asgari Khatun that her husband, it is wrong, my lord, her son, my lord, namely Muhammad Samsad, run over by unknown train in between Lakshmipur halt and Shivnarayanpur railway station. On getting information, she immediately rushed to so and so, so and so. My lord, they planted other story, my lord. Next, my lord, investigation report. During inquiry, RPF so and so, when stated that her husband wrongly married it is son, my lord, may be traveling on train number so and so. Number is here, my lord, 13072, and during this period, he may be fallen down from the train. Falling from train predominantly do occur when anyone travel on foot, board, or at entry, exit, passage of coaches of running train. Thus, it could be said with certainty that due to his negligence and recklessness, he suffered injuries and he is solely responsible for inviting the fate he met. Next, my lord, uh, exhibit R5, my lord. This is very important, my lord. पूछने पर रिलेवेंट पॉइंट, my lord. इस घटना के संबंध में हमें कहना है कि मेरा पति मोहम्मद शमशाद सो भागलपुर में एम्बुलेंस को विष्णु खेतान के घर पर लगाकर रात को शायद ट्रेन नंबर सो से भागलपुर से पीरपैंती आ रहा था और उसी आने के क्रम में वह शिवनारायणपुर और लक्ष्मीपुर के बीच ट्रेन से फिसलकर गिर गया और उसकी मृत्यु हो गया।
Yes.
My lord, I am appearing on behalf of respondent.
Yes.
My lord, may come to page number 24, that is the impugned order.
Yes.
My lord, second para, may I place it?
Yes.
The appellant placed on record the Fard Bayan of Muhammad Zubrail, brother of the deceased, Exhibit A2, wherein it is recorded that his younger brother, Muhammad Samsad, had fallen down and cut from some unknown train near Shiv Narayanpur station at pole number 264 by 45 while traveling from Bhagalpur to Pirpanti. On the basis of the Fard Bayan, a UD case number 37 by 13 dated 9th of June 2013 was registered. FIR, that is Exhibit A1, and inquest report Exhibit A5 mentioned that the deceased was run over by an unknown train. The final report prepared after investigation concludes that the death of the deceased occurred due to run over by unknown train. It nowhere mentions that it is a case of accidental fall from the train. In none of the documents which were filed by the applicants, it was shown that the deceased died on account of fall from the train. On the contrary, the documents show that the deceased had died due to run over by train. The burden of proof rests entirely upon the applicants to prove the untoward incident within the meaning of Section 123C, read with Section 124A of the Railways Act. Now, my lord, page number 25 of the petition, last paragraph. Since the accidental fall has not been proved by the applicants, therefore, the presumption regarding the loss of ticket cannot be drawn in favor of the applicants, and in terms of various judgments of the apex court and other high courts to get compensation, the accidental fall as defined under section 123C2 read with section 124A must be established. There was no recovery of journey ticket. Regarding issue number 2, it was held that the applicants have not been able to prove the death of their son on account of any accidental fall from the train amounting to an untoward incident within the meaning of Section 123C, read with Section 124A of the Railways Act as alleged by them. The issues number 1 and 2 were decided accordingly against the applicants. My lord, Section 123 C2 defines of the Railways Act 1989 defines a bona fide defines untoward incident, which means, may I place it, my lord? 123 C2.
Yes, untoward incidents.
My lord, untoward incident means the commission of a terrorist act within the meaning of subsection 1 of section 3 of the Terrorist and Disruptive Activities Prevention Act 1987, or the meaning of a violent attack or the commission of robbery or dacoity, or the indulging in rioting, shootout or arson by any person in or on any train carrying passengers or in a waiting hall or cloakroom or reservation or booking office or on any platform or in any other place within the precincts of a railway station, or the accident falling of any passenger from a train carrying passengers. So section 123C2 clearly provides that the untoward accident is only the accidental falling from the train. In this case, my lord, the appellants were not able to prove that that the deceased had died due to falling from a train. In the FIR, in the inquest report, uh, as well as the final report, it has come that the cause of death seems to be death due to run over by some unknown train. Furthermore, my lord, the bona fide for the purpose of grant of compensation under section 124, a person must be a bona fide passenger. The explanation to section 124a defines for the purpose of this section, passenger includes. May I place it, my lord?
Yes.
Explanation. For the purpose of this section, passenger includes a railway servant on duty and a person who has purchased a valid ticket for traveling by a train carrying passengers on any date or a valid platform ticket and becomes a victim of an untoward incident. In this case, my lord, no train ticket was found from the person of the deceased during the investigation conducted by the
If
authorities.
if no train ticket was found from the person of the deceased, will it be presumed that he was traveling without a ticket? Do you have any authority on this issue?
My lord, if no train ticket is found from the body of the deceased, so it can be presumed that he was not a bona fide passenger as per section
Do
124a.
you have any authority in this issue?
My lord, I'll have to look
What is
into it.
required? Number one. Number two, what is your inquiry report suggesting? Read your inquiry report.
Just a second, my lord. I'm placing it now. My lord, it seems that I do not have a legible copy of the inquiry report.
There is an annexure. This is there is a exhibited document.
My lord, I do not have the copy of the LCR.
That you are arguing an appeal without an LCR. How can you argue an appeal without a lower court records?
My lord, actually, the file was just handed over us to.
You have started arguments. That
My lord,
means
that is a mistake on my part, my lord.
without an LCR, how you cannot dare to argue.
My lord, I tender my apology, my lord. The matter may be kept after a week, my lord. Will go through the LCR.
After 20 minutes of hearing, it has to be adjourned. You have wasted this 20 minutes.
My lord, I tender my unconditional apology, my lord, for causing inconvenience to the court.
after hearing the case for 20 minutes, when this court asked the counsel for the railways to refer to some exhibits, now it has been submitted by the respondent that the respondent is not in possession of the legible copy of the exhibits. First up. Next, a prayer has been made to adjourn this case. Let's this case on Monday for further hearing.
Apologies, ma'am.
My lord, may we heard, my lord, after vacation, my lord. I am out.
You are not
I
in.
have to present one marriage, my lord.
You are not in need of a divorce. लिखे तो? उसके बाद. At this stage.
Sorry, my lord. Sorry, my lord.
At this stage, the counsel for the claimant, whose claim application has been dismissed, and the claimant is praying for payment of money, and this claimant is seeking a compensation.
Sorry, my lord. Sorry, my lord. I will be available, my lord. Sorry, my lord. Sorry, my lord. I will be available.
Monday. Next.
Case number 34, amendment number 498 of 17, Mr. D.P. Jha for appellant, Mr. Mukesh Shankar Jha, Mr. Manish Kumar for respondent.
Lordship, there are several grounds in this case. First ground is that two vehicles has collided, head-on collision, but only my vehicle has been charge sheeted and other vehicle has been left. Number one, Your Lordship. Number two, the disability certificate they have filed is of 60% only, but the court has taken it as 100%. Third, the injured person has deposed before the court. There are only two witnesses, one injured and one his wife. And wife has become claimant in this case, Your Lordship.
Yes.
For injury cases, wife has become claimant.
Wife is the claimant.
Yes, Lordship.
LCR
And the इसमें LCR मंगाना चाहिए, Lordship. And fourth, Your Lordship, one thing can be seen. Order dated 28/11/2017 when can be seen. Picture of this case would be clear. 28/11/17. This application is under order 41 Rule 5 of Section says has been filed with a player to stay the further proceeding execution case number pending in the Court of Additional District Judge Devgan for realization of the awarded compensation amount 32,54,260 with quarterly compoundable interest 7.5% per annum from the date of default payment of the amount till the date of final payment in connection with motor accident case number such. Learned counsel for the appellant has submitted that from perusal of the impugned judgment, it would be evident that injured is not the claimant, rather his wife has filed the claim application, that there is no authorization letter by the injured to wife or the respondent, wife to respondent, represent him, that no medical paper or opinion of the doctor has been brought on record, that the court below has assessed the compensation on its own, which is not tenable in law, that the entire amount of the compensation has been ordered to be paid to the claimant's wife. In a peculiar case, Your Lordship, two vehicles collided, one has been charge sheeted, another has been left. We have taken a specific plea in the court below in our written statement about this, Your Lordship. And secondly, kindly see the last part of the award, which will make it is very clear. The entire awarded amount has to be paid to the wife. First of all, how he has become claimant when the injured is there. Injured has deposed before the court. He has came before the court. Under what circumstances wife is filing the claim application without any authorization letter. And third, the entire awarded amount should be paid to the...
My lord, may be heard, My lord, maybe heard, my lord, me, my lord, victim, my lord. My lord, the 50% of the total amount of compensation will be fixed deposit in the name of period of 10 years in any nationalized bank. The claimant is the wife of injured Mithun Kumar Pandit, so no one can give a better look after than so the entire amount of compensation will be paid to the claimant itself, my lord. 50% by the name of injured person, my lord, who is on wheelchair, my lord, permanently, my lord. It has come in the impute order, my lord. So far, my lord, issue has been, I have a file, I have petition, my lord, to vacate the original order, my lord, dated 28/11/17, my lord. In para 6, my lord, it is needful to mention here that the respondent succeed the MSCT case facing full-fledged trial. So the present appeal filed by the appellant is fit to be dismissed. While deciding the issue number 1, the learned tribunal clearly held that claim application is maintainable, filed by the wife of the injured, who is on wheelchair and only performs his daily work, my lord.
The interlocutory application IA number 2283 of 2019 has been filed to vacate the order dated 28/11/2017, by which the stay has been granted. Uh, from the order and the judgment, from the aforesaid order dated 28/11/2017 and the impugned award, I find that the injured was not the claimant. The wife had become the claimant, and the court had directed to pay the amount to the claimant. The claimant. Full stop. When the injured is alive, no matter in what state of mind and physique, this court prima facie feels that the amount of compensation should be paid to the injured and not to the wife or any other person. Stop. The preliminary amount, the amount initially has to go to the injured, and then it is up to the other family members and the injured how the amount is to be operated. How the bank account in which the amount is to be deposited is to be operated. First up. In the instant case prima facie, this court feels that the amount of compensation should have been directly deposited in the accounts of the injured. First up. Considering the aforesaid facts, I am not inclined to vacate the order of stay, which was granted on 28/11/2017. First up. This case needs expeditious disposal. First up. Since without the lower court records, the appeal cannot be disposed, the office is directed to call for the original lower court record from the court below. First up, this case to be listed immediately on reopening after the summer vacations. I am dismissed. I am number one, sir. Dismissed. Okay, rest at 2:15.
My lord,
Rest at 2:15.
my lord, in item number 35, it may be placed after the summer vacation, my lord, because elaborate hearing is required, my lord, in this case, and few judgment are to be referred in this case, my lord.
Yes, who are you?
I am for the appellant, my lord, owner of the vehicle. Owner of the vehicle,
You have been saddled with a liability.
my lord. Around till,
Have you paid the amount?
actually, I don't have any instruction, my lord, from the side of, because the owner is a lady, an old age lady.
Pay and they pray for adjournment.
And it's a small prayer, my lord. A small prayer, my lord.
We are not adjourning it. We'll take up this matter. We'll elaborate hearing. We will hear. It's a next case. It's a next case. We'll hear it.
For that purpose, I am praying, my lord, after the summer vacation, it may be
No.
taken up.
No. LCR is here. It's a death case or injury case.
Death case, my lord.
Let it be called out at 2:15.
My lords, a small prayer, my lords, with regard to serial number 33, my lords.
Yes.
My lords, in this present case, my lords, the
This
council
is
opinion. Yes, my lords, it has been done, my lords.
order passed.
It has been kept on Monday, my lords.
Yes, Monday.
Yes, my lords. LCR, my lords, is not with us, my lords.
You get your LCR from where it is. That is your headache.